Hi, this is estate planning lawyer Michael Pevney, and in this video we are going to talk about the 4 dangers of a do-it-yourself estate plan. But before that, if you've got questions about estate planning and want more estate planning information, please subscribe to this page. You can leave a question in the comment section. I will likely respond. And if you live in California, you can set up a time to meet with me for free by using the link in the description. So on to the 4 problems with a do-it-yourself estate plan. People can write up their own estate plans. They can write up their own trusts. In California, where I practice, there's even provisions for handwriting your own will and having it be an effective will. Now, I would never recommend that somebody actually do that. I think it's a terrible idea. But problem number 1 is you don't know what you don't know. So here's an example. A lot of estate plans have documents that interact with each other. Did you know, for example, that a HIPAA waiver, the health information waiver, is an important part of an estate plan? When we set up a trust for somebody, we always put in there trustees, successor trustees for when you're incapacitated and when you pass away. But it's important to have an incapacity trustee. So you're laid up in that hospital bed, you need someone to take over your property who can handle things when you can't do it. In order to do that, you need to talk to a doctor in order to make sure that that person's actually incapacitated so you can take over that. And when you try to speak to that doctor, they're going to say, have they signed a HIPAA waiver? And you're going to say, what the heck is a HIPAA waiver? Because with a do-it-yourself estate plan, a lot of times the documents aren't going to be complete and completed. So the documents all really have to kind of mesh and work together in order to have a complete estate plan. Reason number 2 is that the documents might not be formalized properly. With do-it-yourself estate plans, sometimes you go get some documents online from the internet, you fill them out, or you buy a do-it-yourself software program and you do it yourself and you print it out, and guess what? Nothing's ever signed. I get clients that come to me all the time that said they got a LegalZoom trust and they filled everything out, they answered all the questions, and they printed everything, and they never signed anything, and it wasn't notarized. By the way, a trust in California actually doesn't have to be either notarized or witnessed. It just has to be signed. But if you bring a signed trust that's not notarized or not witnessed to a bank saying, so-and-so died, I'm the new trustee, I need to take over these bank accounts, they're going to say, what are you talking about? This thing wasn't notarized. And you say, well, it doesn't have to be notarized in California. And they're going to say, great, but that's not up to our standards. You're not getting control of this money. So it's important to formalize everything. And that means you and your spouse, or you going to a notary, paying a couple $100, signing all of these documents in front of the notary, getting them stamped, and making sure copies get out to everybody they know. This rarely happens when people create a do-it-yourself estate plan. Another thing most people in California don't know is that a will is not notarized. A will does not have to be notarized, and in fact, if a will is just notarized by one person, it is not effective. If you try to submit it to probate court, they're probably going to reject it, and it won't be a valid will, because a will must be witnessed by 2 people. 2 separate people, they shouldn't be beneficiaries to that will. So it's very important that you have witnesses and you have a notary. I make sure there's follow through with this with all of my clients. I'm standing right there while things are being notarized and witnessed and being executed and carried out with properly. Because like I said, you don't know what you don't know. And that's another thing. Thing number 3, with do-it-yourself plans, you don't really know the questions to ask. It's really all about getting to what your goals are. Do we want to cut somebody out of a will? So if we want to do that, do we just maybe not mention them? Or do we actually mention them and say, this person is related to me and I want them to get nothing? Or we need to really talk about what's the level of sophistication maybe of some of your beneficiaries, or does somebody have special needs, or is there a small business owner, or is there real estate, or maybe multiple real estate properties. Knowing the right questions to ask is one of the most important things that an estate planning lawyer actually does. And that brings me to the 4th reason that I don't like do-it-yourself plans is there's rarely ever any follow through. The big document that I create for most of my estate planning clients is a trust, a revocable living trust. A trust controls what happens to your property both while you're alive, while you're alive but medically incapacitated, when you pass away, and for years after you pass away. When people create a do-it-yourself trust, maybe they'll sign it, maybe they'll notarize it, but you know what they won't do? They won't put stuff into the trust. They will not fund that trust. Because remember, a trust is like a bucket. And a trust with nothing in it, a trust that's unfunded, is an empty bucket. Which means that, let's say, real estate, if you own a home, it's just essential that you gotta get that home into the trust. You gotta fill the bucket with the home. Because if you don't, the trust is going to have no effect on that house. It's not necessarily going to go to the people that you want it to. It's not going to have the protections against lawsuits and liability for your beneficiaries in the future. It's not going to protect them from themselves if they're much too young or if they have special needs. So you've actually got to draw up a deed, write a deed saying, I deed this property from me or me and my spouse to me and my spouse as trustees of the me and my spouse living trust. And it's just so essential to do, because if that isn't done, the trust doesn't have any control over that. And so many times I've spoken to clients who said they did their estate plan themselves, or maybe they did an estate plan in the past with a lawyer that doesn't really focus their practice on estate planning. I'll go into the property records. They'll tell me that the clients will tell me that their house is in their trust. I'll go into the property records, house is not in the trust, because it's got to be written in such a way. There's all these specific forms that have to be filled out, and fees that have to be paid, and boxes that have to be checked, and exemptions for reassessment of property taxes and all this stuff. And so often it isn't done properly. So those are the 4 reasons that I do not recommend that people create a do-it-yourself estate plan. There is so much at stake, and it's just not worth it. If you've got any questions about this or anything else related to estate planning, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. There's a link in the comments section. Please subscribe to this page for more estate planning information, and thanks for watching.